Good morning, and thank you everyone for joining our session today. In today's session, we're going to be focusing on preparing for upcoming workplace law changes. At enableHR, keeping our clients up to date with workplace law changes is a big part of the value that we deliver and continue to deliver to help our clients make sure that they are continually managing their compliance obligations and their people as efficiently as possible. And I'm joined today by Wes O'Donnell. Wes is our National Workplace Relations Manager with FCB. In his role, he oversees our telephone advisory and audit teams and is responsible for service delivery across those functions. Wes has over 20 years experience as a solicitor in the area of employment law and industrial relations. Just a little bit about enableHR. enableHR is a cloud-based best-in-breed HRIS that focuses on helping clients manage and automate compliance and streamline and automate as much of the operational day-to-day HR and health and safety processes. As you can see, we help clients manage employee lifecycle from recruitment and onboarding through to termination and everything in between. Such things as inductions, performance reviews, performance management, and health and safety management as well. We understand that it's not just employees that our clients engage, and we also help them manage life cycle across managing contractors and also managing volunteers. We pride ourselves on making sure our clients are kept up to date with legislative changes, and also making sure that those changes can be simply managed using the enableHR platform's workflows and content. And Wes is going to talk us through some of those workplace law changes today. We're continuing to grow our ecosystem and integration partners that make up our ecosystem, and we'll actually have some new and exciting integrations to share with you all in the new year. So introducing our family. So enableHR is the technology arm of FCB, and FCB is part of the Citation Group, and we're made up of 6 core businesses that fit together and complement each other in providing comprehensive workplace compliance solutions. So FCB Workplace Law has been around for, I believe they're in their 30th year of practice. We also have FCB Smart Visa, which is our visa and migration law practice. enableHR, which is our standalone HRIS platform. HR Assured is our sister product, which takes the enableHR platform and layers it with professional services from across the group, really focusing on 2 streams, being employment relations and HR, and also workplace health and safety. And finally, the most recent additions to our family are QMS certification and best practice certification. Welcome additions and fitting in very nicely into our FCB family. They're great additions because it now allows us or provides us with additional expertise to help support our clients in implementing quality management systems and also taking the journey towards ISO certification. And look, with that in hand, I'll actually hand over to Wes to take us through today's agenda and get us started.
Great, thanks Andrew, and good morning everyone, and thank you very much for taking time out of your busy schedule to join us this morning. As Andrew mentioned, we're going to go through a discussion around some really important legislative changes which have taken effect recently, and discuss in particular how they impact your business and the steps that you really need to consider and undertake in order to address those issues or changes and be compliant. Please feel free to ask any questions through the chat or Q&A function as we go along. To the extent that I can, I will try to capture some of those questions through the course of the presentation and answer as many of them as I can as I undertake the presentation or discussion. Naturally, if I can't get to them, we'll leave an opportunity to ask questions at the end, and Andrew will help me facilitate some of those questions and raise them, and we'll obviously try to capture as many of those as we can. So in terms of today, we're going to go through the recent changes, which is reflected in two major pieces of legislation. The first is the Secure Jobs and Better Pay Bill, or now the Act. It passed Parliament on Friday and is currently awaiting the signature of the Governor General before it becomes law. Changes to the sex discrimination legislation, and we'll talk through some, as I mentioned, some positive obligations and duties that you need to really consider in order to be compliant with those changes. The first thing I want to talk about is the significant amendments which have been introduced to the Fair Work Act. Now, the bill was called the Secure Jobs Better Pay Bill. As mentioned, it passed Parliament on Friday and is currently awaiting the signature of the Governor General before it becomes law. Broadly speaking, to put this legislation in context and the significance of the legislation, I like to discuss the way in which this has arisen. And as we all know, the Labor Party came into the federal election earlier this year without a significant industrial relations platform. As you would expect, the Labor Party did intend to change industrial relations legislation, particularly given that the Liberal Party had been in government for approximately 13 years. And quickly upon forming government, it scheduled what they called the Work Summit, which was held in Canberra in early September. That Work Summit was attended by a cross-section of organisations and businesses, including unions and employer groups and large organisations. And from that came a manifesto in which various amendments and changes were suggested with the intention of driving economic growth and full employment. The speed with which draft legislation was introduced surprised many, but it was introduced in early October. So you can see that it was really pushed through quite quickly. But effectively, the government has indicated that its overall economic policy is full employment and productivity growth. But how it intends to achieve those broad objectives is through greater focus upon gender equality and access for women, believing that effectively greater participation and fairer participation by women in the Australian workforce will of itself lead to greater economic benefits, increased and improved job security for many in the workforce, particularly vulnerable individuals or those which the government considers to be in insecure work models, and the fairer distribution of the growth which is achieved through those particular measures. Now, knowing those broad overarching objectives, the government has legislated in the current Secure Jobs Better Pay Bill. And the main focus is including things upon the prohibition of pay secrecy. And I'll discuss all of those in a moment. Limiting the use of fixed and maximum term contracts, expanding the flexible working arrangements, some significant changes to enterprise bargaining. And I won't probably speak too much on this, given that the implications for enterprise bargaining and on businesses varies quite widely and is often relatively unique to a particular business. So we would encourage you to rather call us if you've got any particular questions in relation to those amendments, and we can help you on a one-on-one basis. There's also an expansion of the small claims division and a significant focus on sexual harassment, and in particular, the requirement to act in order to avoid sexual harassment in the workplace. We do also anticipate that there would be further legislation introduced next year, broadly expecting this around February when Parliament resumes. We don't know the content of the second piece of legislation, other than we do know that there are various things within the government's manifesto and what it's saying publicly that has not been contained in the current Secure Jobs Better Pay Bill. So we broadly anticipate these to be included within Tranche 2. So these are things upon focusing on insecure work models, such as on-hire labour and others, creating potential parity of wages between on-hire employees and direct employees, increase focus upon underpayment of wages, particularly in relation to vulnerable employees, and increasing penalties and potential criminalisation of significant underpayment issues. So we broadly anticipate that these are further changes which will be introduced next year, and of course we'll keep you fully informed of any of those changes if and when they arise. So what I'd like to focus on now is some of the more significant changes which are included within the Secure Jobs Better Pay Bill, and particularly focusing upon what actions we think you need to be undertaking in order to ensure compliance. The first significant change is the prohibition upon pay secrecy provisions. Now, we generally contain within contracts, or it's generally contained within contracts, that there is a requirement to maintain confidentiality in relation to your employment terms and conditions. So some contracts specifically include reference to that. Your terms and conditions are to remain confidential at all times and cannot be disclosed with any other party without the express prior consent of the company. That's normal, and it has occurred quite frequently and widely up until today. The government's view, however, is that the continuation of those pay secrecy provisions artificially maintains and promotes gender inequality within the workforce. With the gender pay gap currently at 14.1%, this is something that the government has been particularly keen to address, and has indicated that one of the quickest and more significant ways in which it can address this apparent inequality in the workplace is to encourage transparency in persons being able to communicate their terms and conditions with others. So to that extent, any term of a contract or industrial instrument which requires or expects pay secrecy is now void. It cannot be enforced, and any term of a contract which expects pay secrecy on an ongoing basis is no longer enforceable. There's also a positive right on the part of any employee to disclose the terms and conditions of their employment to any other individual. So this implies that effectively I can disclose to any person, including direct employees or external parties, the nature of my employment conditions. I'm also able to request other individuals, both current and former employees, to disclose their terms and conditions of employment. Now, although I have a right to request, there is no obligation on the part of any employee I make of that request to disclose their employment conditions. They can refuse or decline. And there is no obligation on the part of the company or the employer to disclose other person's pay or salary conditions if requested by a particular individual. It should be noted that the government has also included penalty provisions within the Act, meaning that in the event the pay secrecy is expected or maintained, well then effectively penalties can be resulting. And given that this is a right, so a right to request, a right to disclose, in the event that anyone in terms of an employer imposes a detriment such as disciplinary proceedings, demotion, dismissal as a result of someone disclosing their terms and conditions or requesting the disclosure of terms and conditions, that of itself would potentially be viewed as adverse action and a claim may arise. So really significant change, and one which we think potentially has some serious ramifications for many organisations. A little bit similar to that, the government views the use of fixed and maximum term contracts as a further example of creating or maintaining inequality and insecure working arrangements within the workforce. In this respect, the government is noting that in fixed term contracts do have their place. They have a time and a place, and they are certainly appropriate engagement models. But the continuation of those arrangements on a regular and systematic basis upon being renewed after renewal creates this inherent level of insecurity. So in that respect, the government has indicated that they are going to limit the use of fixed and maximum term contracts. Now, these particular provisions were subject to amendment when it was brought before Parliament, and there is a 12-month transitional period, meaning these particular provisions won't apply for the first 12 months. But after that, there's a couple of things. Firstly, any individual who is engaged on a fixed or maximum term contract needs to be provided with a fixed employment information statement, much like what you do with all employees upon commencement and with casual employees. Must provide a copy of that statement, must maintain a copy or a record that you've disclosed it. Secondly, you cannot extend a maximum term contract more than once, nor can any fixed or maximum term contract be for a term greater than 2 years. The Act also creates a dispute provision within the Fair Work Commission's authority, meaning that individuals can raise direct disputes with the Fair Work Commission concerning the nature of their engagement or the duration. Now, there are certain exemptions which do apply. However, those exemptions are the responsibility of the engager or the employer to establish that there is a legitimate basis upon which an exemption should apply. So certainly it's a big change to certain organisations, but there are certain exemptions, particularly relying upon government funding where it's not guaranteed to be renewed. That's one exemption which is rather common. But other than that, should also be aware that significant penalties may apply in the event that you contravene this provision. The next aspect is that the government has adopted some wording around flexible working arrangements, which have recently been introduced by the Fair Work Commission in all modern awards. In effect, this wording creates a level of consistency between the modern awards and now the Fair Work Act. Firstly, the circumstances in which an individual can request flexible working arrangements has been broadened to include instances of an individual experiencing family or domestic violence. Next, any individual that raises a flexible working request, there is now a direct obligation to hold a conversation with that employee concerning the nature and effect of the request. There is now a direct obligation to provide written responses in the event that the request cannot be accommodated. And there is now also a positive obligation upon the employer to identify and communicate any alternative role which effectively could accommodate the flexible working arrangements sought. Now, again, very similar to the other areas we've already discussed, the powers of the Fair Work Commission have again been broadened to enable an individual to raise a dispute in relation to these particular circumstances. And again, contravening this particular penalty is now considered to be a civil remedy provision, meaning that failure to comply and fully observe these particular requirements may attract significant penalties both against the company or the employer and any individual who is knowingly involved in that contravention. Now, I mentioned that I don't want to spend significant time on enterprise bargaining, but do appreciate that enterprise bargaining is probably one of the areas that has caught significant focus within the media, particularly in relation to industry-wide bargaining and those type of things. Again, the nature of those particular provisions are often relatively unique in relation to each business. So rather than overly complicating today's presentation, we may leave those particular aspects. However, more than happy for anyone to raise questions in the Q&A function. We can probably address them if time permits at the end, or alternatively, Andrew will be announcing at the end of today's presentation how you can get in touch with us for a more bespoke one-on-one conversation. And perhaps that's an option which would be more suited in these areas. Having said that, though, there's probably a couple of things I would point out. The first is that the bill bill has now introduced rather, that zombie agreements will be sunset after a 12-month period. Now, in effect, zombie agreements are what are referred to as enterprise agreements or industrial agreements, which have been introduced or formed prior to the introduction of the Fair Work Act on the 1st of January 2010. So these are agreements which are obviously predating the current legislation and the conditions and safety nets contained within the current legislation. Accordingly, those enterprise agreements or industrial instruments often contain terms, conditions, or entitlements which are less than or less favorable than what would otherwise be enjoyed currently. The flip side of that is that those businesses which are able to continue operating under those pre-modern industrial instruments often experience a significant commercial benefit compared to their competitors within the space, given that they're not necessarily needing to offer identical terms, conditions, and wages. So what the government has proposed is that those zombie agreements will be phased out after an initial 12-month grace period. There is, however, the ability to apply to the Fair Work Commission for an extension of that grace period, which will be assessed against various criteria. But that grace period or additional period cannot be extended beyond a further 4 years. So really important that we understand that any business which is currently utilising or trading under a zombie agreement needs to consider that after a period of time, whether that's 12 months or some other greater period that the Fair Work Commission approves, you will effectively come out from that structure and will be required to engage people based upon the terms and conditions of the corresponding modern award. Now, that of itself means that you're going to have to go through a plenary process to ensure that you understand what those terms, conditions are. But I would imagine that in most circumstances, it may result in a significant increase in your labour cost, meaning that you're also going to have to consider what those direct cost implications are and plan for it accordingly. There are also significant changes to the way in which enterprise agreements are bargained, but also the boot test. As we know, the boot test, the better off overall test, has been broadly criticised over the last 4 or 5 years in relation to the stringent application of that test and the very limited beneficial circumstances in which employers find themselves in, after an agreement is reached. The legislation seeks to apply a more global assessment to that boot assessment rather than a line-by-line comparison, which I think is viewed pretty positively by most individuals, groups as a result. So they're probably the more significant changes which have been proposed through the Secure Jobs Better Pay Bill. What I'd like to now discuss is 2 further changes focused upon addressing sex discrimination in the workplace. The first is the amendment to the Sex Discrimination Act to particularly address the likely occurrence of sexual harassment in the workplace. And what this change has done is it's created a positive duty upon employers to undertake all positive steps and measures as far as reasonably practicable to eliminate sexual harassment in the workplace. Yeah. Now, this really closely mirrors the concept within work health safety legislation around requirement to identify and eliminate, to the extent that is reasonably practicable, any hazard within the workplace. So closely mirrors that type of language. Although positive duties, which are necessary, has not been defined within the Act, there's a summary document called an explanatory memorandum which sits next to the bill, which does outline there are various things which would be expected to fall within that definition. And they may be things such as introducing a sexual harassment plan, and much like you would do with WHS, identification of a hazard, which in this case is sexual harassment, and what steps are necessary in order to effectively reduce or eliminate that over time. Now, that plan will map things out over the course of your HR cycle. So contracts, policies, implementation, onboarding, training, refresher training, systems, etc. The explanatory memorandum also makes reference to regular training, and depending upon the size of your organization, may also suggest staff surveys, data collection, complaint processes, anonymous whistleblower processes, and other things. Now, the Act builds upon the current provision, which is Section 106 of the Act, which says that an employer is liable to the extent that it's taken steps and measures to avoid it. And now it states, and it's built upon that even further, to say that employers are vicariously liable for any damage arising from sexual harassment in the workplace, except if they have undertaken or complied with their positive duty obligation. So again, emphasizing that there is a positive duty to address sexual harassment as a potential hazard in the workplace. There is a positive duty to undertake all reasonable steps and measures to eliminate or reduce it to the extent that is possible. In the event that you don't comply with your positive duty, well, then you are directly liable for the hurt or damage arising from that sexual harassment in the workplace. The other, I think, very positive change is creating a new concept of hostile workplaces on the ground of sex. So currently, sexual harassment requires a level of conduct or behavior directed towards an individual, which is unwelcome, sexual in nature, and which is likely to result in humiliation, intimidation, or offense. But that of itself doesn't necessarily address the culture or the values or the nature of the workplace in which we find ourselves. The changes now create an offense of subjecting an individual to a workplace environment which is hostile on the grounds of sex. Okay? Now, obviously, there's a scale, and that scale will be determined by the seriousness of the conduct, whether it was repetitive or isolated, the nature of the individuals involved, the size of the organization, etc. But this speaks more to the actual culture of the organization, the nature of the workplace itself. So, is there banter? Is there inappropriate posters or imagery displayed? Is there comments made in relation to someone's gender, etc.? So that's a hostile environment in relation to circumstances associated with someone's sex. So those acts are now prohibited. The powers of the Australian Human Rights Commission will also be broadened, and there's a 12-month period that this will transition in. So effectively the changes will take place in 12 months' time. But now the Australian Human Rights Commissions not only have the power to hear a complaint by an individual, but also have powers to conduct inquiries relating to what steps an employer has undertaken in compliance with these positive duties. It's also empowered to issue compliance notice or notices and enter into enforceable undertakings with organisations. Now, the nature of those enforceable undertakings haven't been brought out as yet, but enforceable undertakings undertaken by the Ombudsman involve a level of public disclosure. So it may be that the enforceable undertakings of the Australian Human Rights Commission are similar in that approach, meaning that there's a very significant brand or reputational issue which results in the event that there is any form of investigation or inquiry made where there are adverse findings or an enforceable undertaking resulting. So couple of steps initially, which we'll go through in a moment. And this is probably very similar to what we've discussed in the context of WHS conversations. Probably the first step, which isn't on that slide, is to understand the legislation and what your obligations actually are. So what are your duties? What are your obligations? What is the nature of the legislation as it impacts upon the organization? Identify the hazard and then the risks. The hazard is sexual harassment in the workplace, sexual discrimination in the workplace. What is the risk of this hazard arising? How reasonable is it that this will occur? And secondly, if it does occur, what is the significance or nature of the injury which may arise? Identify what some of the reasonable and proportionate steps are that you can implement to address these changes. Now, I would strongly suggest that you engage with your work health safety committee or a broad cross-section of your workforce. Make sure it's obviously gender inclusive to identify other staff members' views on the culture, values, how we can potentially address sexual discrimination and harassment in the workplace. Encourage a reporting culture, like what we do with WHS. It's just known now that if anyone has any form of physical injury, it must be reported immediately. It needs to be the same with sexual harassment, bullying as well. Bullying, harassment, sexual harassment, they are of themselves work health safety issues. We know that psychosocial injuries are clearly associated with experiences of bullying, harassment, sexual harassment. We should therefore encourage or expect rather all individuals to effectively report upon and escalate any of these types of matters within the workplace. Create a framework of compliance. Look at your engagement documentation, look at your engagement and implementation induction process. Look at refresher training and awareness training. These are all steps that need to be considered. Now, not having to undertake all these steps immediately, we appreciate and acknowledge that some of these steps may be difficult for businesses to implement immediately or with the amount of business critical steps and measures that you have in other areas. What your obligation is however to understand the risks, implement controls over the forward HR cycle. But remember, if you're deemed to be not meeting the positive duty test, you can't fall back on that defense to avoid vicarious liability. So yes, we're happy that this is deployed out throughout the course of the forward HR cycle, but you don't want to defer it too far because otherwise that may impact upon your ability to rely upon that positive duty defense in the event that there is an issue which is raised up. The last thing I quickly want to talk about in the time that we have left is just in relation to further amendments in the Secure Jobs Better Pay Bill. So we've talked about this already, but I've separated it out because there are other provisions specifically in relation to avoiding sexual harassment within the workplace. So I want to talk about it separately. So we know that there are changes to the Sex Discrimination Act aimed to avoid and minimize sexual harassment in the workplace. There is now a direct provision in the Fair Work Act. Surprisingly, you may be surprised to learn that there is not currently a law which states in the Fair Work Act that you can't sexually harass people, but now there is a specific provision which prohibits sexual harassment in the workplace, which states that basically a person must not sexually harass another person who is a worker seeking to become a worker, so a candidate, or another person in connection with a person conducting a business or undertaking. So notice how these definitions are wider. So it's not limited to an employee, but rather much wider in terms of workers, candidates, on-hire workers, other individuals engaged or connected with the PCBU. And they're terms which are widely used in WHS legislation and broadly understood. So you can see how this obligation or the prohibition upon sexually harassing individuals is not limited to the direct linear employer or workplace that you're operating in, but rather any worker candidate, other individual in connection with that workplace, which is really significant because it extends an obligation of safety to all of those persons connected with that establishment. As we've discussed before with many of the changes in the work in this space, there is a introduction of a penalty framework, meaning that if any person contravenes this section, so a person does sexually harass someone in the workplace, well then that's now considered to be a breach of a civil remedy provision, meaning that significant penalties may flow. So with that, it's really important to note that, again, there is a further amendment to the jurisdiction of the Fair Work Commission. So again, we're seeing all these changes to the law, which is coupled with empowering the Fair Work Commission to hear disputes or issues associated with the matter, but coupled further with a penalty regime which is implemented. Now, within the Fair Work Commission, there is now the ability for a person to pursue what's called a application for orders seeking sexual harassment to stop. The Fair Work Commission has the obligation to hear that matter as soon as possible, and in the event that they determine that sexual harassment has occurred in the workplace, they are able to make any order that they see fit with a view to making that sexual harassment stop, with the exception of monetary compensation. In the event that someone does not bring an application for orders to make sexual harassment stop, there is the ability to raise a dispute with the Fair Work Commission in relation to this alleged conduct as well, or the failure to maintain a safe workplace, or someone acting in a manner contrary to the obligations. So, last little bit before we take your questions. There's been a lot of changes which we've gone through there. And perhaps suggest that the significance of this legislation is really reflected in the fact that all businesses, regardless of size, complexity, location, are required to act. Yeah. Often within changes to legislation, it may impact only larger businesses or businesses undertaking enterprise bargaining, etc. You can see that the changes which we've discussed today broadly impact all businesses. So, with the need to understand these provisions and act upon them certainly applies to all organisations. So the first thing is to obviously become aware of the changes and the obligations which flow from it, and that's part of the objective of today. We will be sending out more communication, scheduling greater number of events in future to ensure that where there's any changes or information that we think is necessary, we'll of course keep you fully informed. Secondly, assess your compliance with that. So things like do your contracts contain pay secrecy provisions? Does your organization expect the maintenance of pay secrecy? Have a look at your gender pay gap. Is there a gender pay gap which exists? People doing similar or like roles. Can you objectively justify why there's a gender gap within your structure? How would you potentially respond in future in the event that one of these issues are arisen? Do you wish to put in place some mechanisms, particularly in relation to the appraisal process, that you're affording future pay increases in a manner which is not associated with gender or closes the current gap? Are you using fixed term contracts? Are your policies aligned in relation to flexible working arrangements? Is your business at risk of any particular adverse view around sexual harassment and the likelihood of sexual harassment occurring in the workplace? Would your working environment be viewed as hostile on the grounds of sex? Critically assess your organization's compliance with these obligations, and do it much in the same way as you would with a really critical lens from WHS perspective. And don't view any breach or inconsistency with negativity. It's an opportunity for you to address these matters and to get in front of them. Next thing is to map out what you need to do to become compliant. Now, remember, in some areas, fixed term contracts, for example, there is a deferral for 12 months before they're effectively implemented. So consider where is your biggest risk? Where is the most focus and attention needing to be adopted? Map out how you're going to address those particular factors over your forward HR cycle. Really important to map that out and document it. So if effectively there is a power of inquiry from the Australian Human Rights Commission, or if the Ombudsman undertakes a review, you're able to provide them with evidence of your positive duties that you're undertaking in order to address these risk profiles. Update your systems. Again, we want to encourage a reporting culture. Do our systems enable us to accurately capture improvements undertaken in these areas, but also for employees to raise concerns, grievances, issues for the attention of management to act? And of course, get some advice wherever necessary from experts. Now, to the extent that we need, we're currently finalizing changes to workflows and documentations which sit within the enableHR platform, which is fantastic. But naturally, there may be a need for some further bespoke support, and Andrew will step you through how we can potentially give you some further assistance to that effect, and then we'll go through some questions and answers. Thanks, Andrew.
Thanks, Wes. And yeah, there's certainly seen some questions popping up as we've been going through. So look, if anyone is interested or would like any additional details on how enableHR or FCB more broadly can actually help keep your business compliant and on top of legislative change, please feel free to reach out for a detailed demo of the enableHR platform. You can request a demo quite simply through the URL that's on the screen there. Or you can simply head over to our website and reach out via that channel, and one of our expert team can certainly get a meeting or a demonstration set up for you to explore how we can help you. So over to the questions. There's been a few that have come through, so I'm glad we've allowed some time for that. So first question that's come through here, Wes. It's probably a bit of an interesting question, but what are the practical changes which I need to implement?
Yeah, good question. It really depends upon your compliance with some of the matters which I've discussed. Some of the immediate practical ones that we're seeing a lot of clients needing to implement is reviewing contracts around the pay secrecy provisions. So have a look at that. If your contracts have pay secrecy provisions, well, obviously you'll need to either continue under the current framework for those employed, which because there's a clause which says that those provisions are void. But secondly, you can't issue contracts anymore to any new employee with those provisions contained within it. So you'll need to update that for future candidates or current candidates. Other things you'll need to consider, I think, is identify whether there is a gender pay gap and the reasons for it, and consider ways in which to close that out. Consider how you align pay increases with your appraisal system. I think that's an easy win and something that you should be considering. If you've got fixed term contracts and use those frequently, I think we need to consider if you would normally engage people for more than 2 years or renew them more than once, in which case, again, that is something you need to consider as an alternative. How do we address that in another engagement model? And the biggest one is just those positive steps needing to address and potentially eliminate sexual harassment in the workplace. So are we doing enough in that space? Do we have a dusty policy on the shelf which you're not really utilizing or living? Do you need to update your policies? And I think most businesses would. Do we need to update policies? Do we need to effectively communicate it to people? Do we need to make sure that they are indicating their acceptance and awareness of it? Are we undertaking frequent training and development around people's expectations and expectations of behavior within the workplace? So lots of immediate steps, I think, in those areas which need to be undertaken. I do think that what you would do is identify where you've not necessarily met the threshold requirements or expectations of the various acts. much like what you do with WHS, and then plan it out. What is the likelihood of these issues becoming a problem? How important are they? How critical are they in terms of potential impact to an organization or individuals if they do occur, and map them out over the forward cycle. So that's what I would suggest you do. Now, the timing of this new legislation has been really unfortunate, because obviously we've got lots of people on leave, lots of ongoing projects, urgency with matters as we finalise the year out. So lots of things for us to address and undertake, but there's some of the initial steps I think you should be looking at, and probably some of the more practicable steps that you should be addressing in the short term.
No, thanks, Wes. Second question, again, is another interesting one. So the question is, I can anticipate a lot of issues arising from people disclosing their salary. How can we best address this?
Yeah, it's a question I'm getting a lot, actually. So not surprised that I've got it again. First of all, I think look at your structure and have a look at your pay within various roles. And remember, it's people doing similar or like roles. Consider whether there is any potential disparity which could be argued to be on the basis of sex. Okay, we are seeing in the last couple of years a very tight recruitment market. So we are seeing that people are expecting greater salaries, terms and conditions than would otherwise be the case. So it might be that there is an objective reason that there is some level of disparity in wages. I suspect that people will start disclosing, or at least requesting. May not be immediate, but it will creep in over time. And those conversations, I think, are inevitable. And once people are familiar with the fact that they can disclose these issues, well, then they'll be more comfortable in doing it. I'm not sure whether people are necessarily across this right, so immediately. So I'm not sure if it's going to be an immediate thing or in future. But I think organisations need to be armed with a level of knowledge within their business operations and experience to be able to effectively respond to questions should they arise. So, is there a wage disparity amongst sexes within the workplace? If so, is there an objective reason for it? Be prepared to speak to that objective reason. Also, think and be prepared to speak to positive proactive steps that you're going to implement to ensure any gap is closed out, but also future wage increases are afforded based on performance, productivity, contribution rather than gender. And the easiest way, I think, to do that is to link pay increases to appraisal outcomes. But I think biggest tip, if you're anticipating some type of dispute, or you're concerned that there may be a level of disparity based on gender within your pay, your labour structure, consider, is there an objective reason? If not, let's get onto it straight away. If there's an objective reason, let's be prepared to speak to it, but also be prepared to speak to how we're looking to close that out and address it with a degree of equity over time.
Okay, next question. I'm not a large business with an HR department. In meeting the positive duty requirements under the Sex Discrimination Act, am I expected to do the same things as a large business?
Yeah, good question. In short, no, but it doesn't necessarily create a defined structure in terms of, businesses with X number of employees are expected to do this. Next bucket of businesses in terms of medium-sized organisations are expected to do Y, etc. There are a couple of examples within the explanatory memorandum which set out two different businesses which have two different employee groupings or sizes and complexity, and the steps that they've undertaken differs. In short, yes, the answer is that the requirements placed upon you will differ depending upon your size and relative complexity. But remember, some of the things that I've spoken about aren't necessarily complex or costly or difficult to implement. You should have the existing framework within your WHS structure to do it, and you just need to take steps and implement it over time. I would certainly be recommending that all businesses have a sexual harassment plan. Certainly recommending that you're looking at your engagement documentation and your induction process. certainly suggest you be looking at training, refresher training, development over time, and making that a regular and consistent thing. Most certainly look at the reporting framework and the notification framework. So how do people raise complaints? Create an environment where you're actively encouraging people to raise complaints or report. Have a look at your systems in place where you may have a anonymous whistleblower service, and other functions. Now that may depend upon your size because that has a cost. But yes, there are certainly changes in the expectations. Those changes are not specified within the Act, but I would be recommending that there are lots of positive steps that an organisation could take to eliminate this. Also think about just really simple things. If you have a WHS committee, raise it with your WHS committee. It's not necessarily an indication that there is sexual harassment in the workplace, but put it to them. Say, you're obviously closer to a larger cohort of workers. How do you think we can effectively communicate our values, our expectations, and make sure that people are comfortable in raising issues? So, consult, engage, get a broader viewpoint and perspective on how you may implement effective control measures.
Thanks, Wes. Look, if we don't get a chance to get to your questions that you've asked, don't worry. We'll certainly reach out post the session to make sure that we're responding to any questions that are raised. So don't worry if we don't answer your question. We certainly will make every effort to come back and make sure you've got the responses that you need. So look, probably a couple more. Wes, I think we've got some time for. So next one is we use maximum term agreements with our workforce as we are dependent on government funding.
Yep.
So we also can't use government funding to pay redundancy costs. So how do we approach this?
Yeah, it's a difficult one. And I think that the government has anticipated that there are many organisations which utilise fixed or maximum term contracts because they're dependent upon government funding. There are a number of exclusions which are existing within the legislation. So if you are using fixed and maximum term contracts on a regular basis, strongly recommend that you contact us or any other service or through the information that we provide to ensure that you're actually meeting within one of those definitions of exclusions. The reason being is that the obligation is upon you as an employer to satisfy that there is an exemption which applies. Yeah. Government funding is an exemption where the renewal of the government funding is not guaranteed. Yeah. So that is one exception. A couple of clients that I have in this space, I'm talking about amendments to their contracts where there is now a positive acknowledgement on the part of that employee that their role is subject to government funding, which is not guaranteed to be renewed, and that they acknowledge and agree that their employment falls within the exemption within this particular legislation. Now, that's not a foolproof solution, but it will go a long way, I think, if ever challenged, to acknowledge that the employee is aware of this and acknowledges that their role is fitting within that particular exemption. So I think with your example where you're talking about roles being dependent upon government funding, I'd strongly suggest that you reach out and we have a more bespoke conversation around the nature of your business, the nature of the government funding, how long it's been provided, whether there's a competitive process at the end of that period or whether it's simply renewed, those type of things.
Certainly a question that's come up as well in some of my conversations. Look, lastly, question here for you, Wes. We operate under an expired agreement from 2008.
Mm-hmm.
We can't afford to move to the terms and conditions under the award. Mm-hmm. What are our options?
Yeah, so first thing is that if you're operating under a zombie agreement, the zombie agreements will effectively sunset, meaning that they no longer apply after an initial 12-month period. Okay, there is the ability to seek an extension of that 12-month period up to a further 4 years maximum, but you need to go before the Fair Work Commission, and there needs to be well, sorry, I should go back and said there are limited circumstances in which the Fair Work Commission can exercise that authority, and you need to satisfy that you fall within one of those categories. The first thing I probably suggest that you do is, if you are operating under a zombie agreement, I'd be strongly suggesting that you start a plenary process as quickly as possible. And that may include a comparative analysis between, what you're currently affording or offering your employees under your terms of your zombie agreement, what the comparative terms and conditions under a enterprise agreement or modern award will be, including a comparison of the differences in financial terms and conditions. You can then do an analysis to determine the cost that this will incur, and then that will drive a planning process in anticipation of that zombie agreement sunsetting. So there are limited ways in which you can potentially expand or defer rather that sunsetting provision with zombie agreements. Even before you start considering making that application, there will be a need, however, to undertake that plenary process so you understand precisely what the comparative terms and conditions are and the cost implications to your organization, and then suggest that you reach out to us and we can help you through that assessment and what the next steps are in order to address that.
Thanks for that, Wes. And look, that concludes our session for today. Thanks again, Wes, for joining us and making yourself available to answer questions. You always seem to get the doozy questions, mate. So thank you. And look, thank you to everyone who's joined us today and registered for the session. And look, we really appreciate you all taking the time this morning to join us and talk about these key topics. We will make the recording of the session available post. And look, if you'd like to reach out for any additional information and a demonstration of enableHR or discussion more broadly, as Wes had suggested in a couple of those responses, please feel free to reach out to us directly, and we can certainly set up a session and further discussion with you. So again, thank you everyone for coming. Hope you all have a wonderful day, and we look forward to connecting with you all again very soon. Thank you very much.
Thanks everyone. Have a good day.